afternoon and welcome. Thank you so much for taking the time to be here. This kind of a turnout, I think, really speaks to how much care and concern is in our community of service providers. And so we just want to thank you for taking the time to come. This is the second of kind of a continuing conversation that we've been having, and we hosted a first forum with attorney Mark Krokish, and it was so well received from so many people that we really wanted to build off of that day and build our panel and invite even more people to come. So I just want to say thank you to Dakota County for your partnership in helping to spread the word, and to Prince of Peace and for hosting us today. And I think we'll have the panelists come up at this point. We're going to structure the day this way. So we have 2 hours together. The first hour is going to be spent with some questions that we've actually come up with ahead of time. And the second hour will be open for you to come and ask questions right here in the mic in the middle. The questions were put together by 360 Communities Diversity Work Group, the DWG, affectionately called the DOG. So the DOG put the questions together, and Kieran Bradley is going to be our moderator today, and she is going to ask the questions. They will also be displayed up on the screens on each side. And so with that, I'm going to have the panelists please introduce yourselves, and then we'll get started.
Good afternoon, everybody. My name is John Keller. I'm the Executive Director of the Immigrant Law Center of Minnesota. We are the state's largest provider of free legal services to immigrants and refugees who are low income. If you're familiar with the idea of legal aid, we are basically legal aid for anybody who needs to interact with federal immigration services. Could be a citizen who's married somebody who's abroad, or family members reuniting through the immigration process. I'll talk more about our work as we go.
And my name is Mark Krokish, and I was here a few weeks ago for the first one of these. I'm an immigration attorney. I work in a private law firm. We do exclusively immigration. We have about 6 attorneys, and I've been doing this for about 11 years or so.
I'm a family law attorney with Wilson Law Group. Like I said, my name is Kathleen Kornienko. I handle exclusively family law cases such as divorce, custody, adoption, parenting time, child support, that sort of thing. In my firm, we have about 10 immigration attorneys, so I get a lot of my clients from that side of the firm. And there's a lot of intersection with immigration and family law, which I'm sure we will get into today.
Welcome. Thanks, everyone. Again, I'm Karen Bradley. I work in the Child Care Aware School Success area of 360 Communities, and I'm just going to be the facilitator. So we'll ask questions and have them go through them right now. Hopefully that will answer a lot of your questions, but we also will have time for you to come up to the mic after about the first hour. So jot them down if you need to. So we will start with preparedness. Documentation. What type of documentation should people have on their person to prove their residency status?
I'll start with that one. So if you have some type of immigration status, whether it's a green card or if you are in the process of it, or if you have a work card, you're required to carry those with you at any point. We actually heard a story a few weeks ago about an individual in California who had DACA, a dreamer status, but he wasn't carrying anything with him and was summarily deported to Mexico even though he had legal status. That was one of the issues that was in the news recently. So if you have any type of immigration documents from the Homeland Security, you should be carrying that with you. And if you don't, that gets to one of the things that we talked about the last time is we're still unsure if the administration is going to expand what's called expedited removal. And if they do, what we're advising is to carry some type of proof that you have been in the United States for more than 2 years, which may be net receipts, bank account statements, anything like that, so that you can demonstrate that you've been here for more than 2 years and therefore have claim to the due process rights of a normal immigration court removal hearing.
in the process, and that's a very broad concept, but you should have a receipt of some point from Homeland Security, and that's better than nothing if that's all you have is that receipt, in the example that Mark pointed out. The other suggestion we're making for those folks who are undocumented, who do not have proof of legal status, it is still important to carry proof of who you are, and this most often comes into play with local law enforcement, not immigration, but local law enforcement. How do you prove who you are if you are pulled over for a speeding ticket or you're in an accident? And most jurisdictions will accept a passport or a consular ID as proof of who you are, and that can be helpful for interactions with local law enforcement. Not to prove you can drive, but to prove who you are.
These days, many people keep records of things on their cell phones. They can take pictures of things. What are the ramifications if they keep electronic copies on their cell phone or computer?
I would just say from my perspective, I have not seen this be an issue, at least in the context we're talking about it. I think the way the question is posed is if you don't carry your I-94 or your green card, but you have a picture of it on your phone, I certainly think that a reasonable law enforcement agent would see that and see the image, if there's an image of you, and say that that's probably sufficient until you can produce the real thing, if they insist on that. Again, we're talking mostly about immigration enforcement. Where we have seen more controversy and more interest around electronic devices is at the port of entry. If you're arriving at an international inspection from a trip abroad or at a land border to make entry, there's been a lot of news about what can Border Patrol or ICE force you to turn over. Can they make you show all your Facebook updates if you're on Facebook and things like that? And that's a developing area of law. It has arisen in kind of prominence because of a couple of lines in the executive orders that the president mentioned. The general rule, I'm not an expert in privacy, but what we've generally read, and most of this comes from the ACLU, is that if you are not a citizen, you're making that entry into the United States, and if there's a suspicion that you could be somebody that wants to do harm to the United States, there can be an insistence to check all of your electronic devices by Homeland Security, to the extent that if you do not comply, you can be held and detained, or certainly your devices can be detained. That suspicion supposedly also rises for U.S. citizens, and what we've read and what I think the ACLU has been saying is even a U.S. citizen who's arriving, if you do not comply by turning over your device or your passwords, your device could be confiscated. So I would say stay tuned to that issue if that's part of what was behind the question.
No, I was just going to add that it's a developing area of law, and I think there's even a case at the Supreme Court right now on data privacy at the border, and we'll see what happens with the development law.
I would just say, to be clear, even though I think most reasonable immigration enforcement would look at an electronic version of your proof and take that as likely to suffice, the law still requires that you carry the actual documentation on your person at all times. So I want that to be clear. Most people don't know that. It's not a very commonly enforced requirement, but it is the law.
Okay, so still in the spirit of preparedness for parents and their children, guardianship. If parents are concerned about detention, deportation, and want to prepare ahead of time, is there a standard procedure they should follow to pass guardianship to another adult?
So guardianship is actually not the right term to use in this case. When we're talking about children, typically we talk about custody. So there are ways that parents can transfer custody to another adult if they fear deportation. One, but not all of them will work in each situation. So one of the easiest things to do, and one thing that I've been hearing a lot of from people coming into our office, is to do a power of attorney, basically, or a delegation of parental authority. This is a really pretty simple document. There's a template that's online. People can fill it out, plug in the right information, and get it signed in front of a notary. And that will basically transfer custody of children to another person. So the parents are transferring custody to another person. The issue with the delegation of parental authority is that it takes place, or it takes immediate effect. So right then, as soon as it is signed, the parent has transferred custody to that other person. So for parents who are not in deportation proceedings, who are not maybe knowing that they're going to have to take voluntary departure shortly, or some sort of circumstance like that, delegation of parental authority may not be the best option for them. Another option for people who are simply scared is what's called standby custodianship. If you fear deportation or actually pretty much any other kind of triggering event, you can establish documentation that grants custody to another person for your children that only happens if this triggering event occurs. And those triggering events are chosen by the parents. So that could be deportation of one or both parents, that could be death of the parents, or incapacitation due to illness, being in a coma, that sort of thing. So it's actually something that can work not just for parents who are fearing deportation, but any other sort of grave life situation. The issue with a standby custodian is that it takes place upon the triggering event, but it only grants custodianship for 60 days unless the standby custodian files it with the court. So it's a little bit more complex than the delegation of parental authority, but you don't have this issue where the transfer of custody immediately occurs. So that can kind of help people to feel a little bit more secure, I guess, in going forward with their lives. Finally, the most extreme way to transfer custody to another person is through a third-party custody case. And that is a court case in which there's a court order that permanently transfers custody, permanently in the sense that it can always be modified, but there's no 60-day rule, there's no 1-year rule, anything like that. And so that would be the case for parents who know they're going to be deported, want their children to stay in the United States, and want them to be taken care of by a specific person. There's kind of these 3 different options for parents.
Okay. How can this be, or how should this be documented for schools' use?
So some of the advice I've been giving to my clients who are just really scared is not to even necessarily do a delegation of parental authority or a standby custodianship, but just to make sure that all of their information at their children's schools is updated. So I'm sure most parents have an emergency contact for their children. Make sure that the emergency contact who you signed up in September is still someone who you want called if something happens. I think each school is going to be different in what they require from parents, but certainly what I've seen is that either a delegation of parental authority that is properly executed and notarized is sufficient. Same with a court order. Schools certainly respect a court order granting custody to someone. I haven't seen any issues or schools requiring any other documentation.
If an undocumented student is turning 18 and wants to apply for citizenship, what is the process? What resources should they consult? And what role should the school play in this process?
Okay, there we go. Okay. Well, it's actually a lot more complicated than just that, because an undocumented person actually is not eligible for citizenship. You need to actually have lawful permanent residency or a green card before you can apply for citizenship. So if the child turning 18 is truly undocumented, then they need to figure out what path are they going to take in order to get to the position where they can apply for citizenship. If they've been here since before age 16, lawyers' advice as far as what type of path might they look for. Generally speaking, in order to get a green card, you have to have some type of hook to the United States, whether it be a family member or an employer to petition for you. So an 18-year-old probably has a long way to go before they're going to be able to get a green card unless they're going to fall into one of the more unique areas of immigration law.
I would just say, the question might also have meant to be something like, if you are in schools and you're working with a lot of young people who are reaching their 18th birthday, and they do already have their green card, so now they're reaching this point where they could apply for citizenship. This is a common scenario, particularly with refugee young adults, if their parents have not become citizens themselves and helped their minor children become citizens. At the age of 18, somebody with a green card who's had that green card for 5 years can apply on their own. So that's really a moment of adulthood in multiple ways in this context, applying for citizenship. Our advice, if you're low income, certainly you can call our office. We do have a very robust program for citizenship for persons 18 to 80 and who are low income. We've got really wonderful participation from private attorneys who will take on pro bono cases in this regard. Not everyone needs an attorney to apply for citizenship. Generally, if there was no issues in acquiring your permanent residency, if everything went without a hitch and without any trouble, and you've had no interaction, no arrests, no convictions in the U.S., no long trips outside of the United States, many people do apply on their own. Our suggestion always is, before you do that, at least review. Our suggestion is with an attorney and see if there are any red flags, and if not, go ahead and do that. One thing that we've been talking a lot about for years now is in Minnesota, there's anywhere from about 75,000 to 85,000 permanent residents in Minnesota eligible to apply for citizenship. So there are tens of thousands of people in Minnesota who, in their own best interest, in their family's best interest, should get advice and, in our opinion, take that step to naturalize. It protects you from deportation. It gives you more opportunities to make more money, to sink down roots in your communities, buy homes. And as I started to say, if you're a parent and you apply for citizenship while your children are under 18, if they have green cards, almost always those kids will also automatically become citizens. So there's a real multiplier effect for not just the parent, but also for those children under 18 who have green cards.
All right, we'll move on to detainment. So, ask being prepared. How long does someone need to be a resident in the country in order to have legal options and opportunities available to them?
I'll start with that. Actually, everybody who's physically present in the United States, whether they're documented or undocumented, does have certain due process rights and constitutional rights. The short answer for people who may have the least amount are the current executive order as far as expedited removal would be if you've been in the United States for less than 14 days and found within 100 miles of a border, then you don't have the due process right to normal immigration court removal proceedings. But once you're beyond that, you have due process rights. You get to talk to an attorney, you get to be able to defend yourself in immigration court. So it's just that real fine line there about the first 14 days and within 100 miles of the border, unless the administration is going to expand it. I think that would have to go through a notice and comment rulemaking, so it's unlikely to happen real soon if the administration is going to expand it to the full 2 years, which is what the statute allows as the outer bounds of that.
The other thing I would say, and we've been doing a lot of conversations with the immigrant and refugee community on this very question, so it's a good question. it's just to be clear, what Mark was mentioning is in the January 25th executive order issued by the administration, they propose in that executive order to dramatically change expedited removal or expedited deportations. And that dramatic change that Mark talked about was currently that kind of procedure of deporting somebody without seeing a judge can happen if you are unable to prove you've been here more than 14 days. That change, if it becomes law, would require anyone that immigration encounters to prove you've been here 2 years or more. So there's a very dramatic change if that were to happen. The second dramatic change in expedited removal is that it would not apply only within that exclusive 100-mile zones of the borders, but rather it would apply in the entire country. So as of this date, that's not happening, but it is called for in the executive order, and as Mark mentioned, we believe the analysis on our side is that in order for them to make that change, they would have to go through formal rulemaking, and there certainly would be more news about that if that were to happen. Back to the question of to really put on a defense if you're facing deportation, this is an extremely complex area of immigration law, and we encourage anyone who is detained or facing detained or fears that they may be detained to get a consult, a preventative consult, with a qualified immigration attorney so that they know beforehand what their rights are. There is probably the most common defense to deportation for most people who've been here a good number of years is something called cancellation of removal. There's a lot of confusion about this defense, but it has 3 main requirements. You have to prove you've been here at least 10 years continuously. You can't have long breaks in your residency in the U.S. You must, second, have at least 1 U.S. citizen child or spouse, or U.S. citizen child or spouse, or I'm sorry, permanent resident child or spouse. So you have to have somebody very close to you who has lawful status already. And then third, you have to have basically a clean record or a relatively clean record and be worthy of discretion at the end of your hearing. So that's cancellation of removal. One of the things we talk about in the current demographics of the undocumented population is the average length of time for somebody who's undocumented in the U.S. is 15 years. Most people don't know that. So people have been here a very long time. And there's an estimate of between 4.5 to 5.5 million U.S. citizen children who have at least one parent who's undocumented. So we know that a significant number of undocumented people nationwide would qualify, at least on the bare demographic information, for this cancellation defense.
And just one follow-up on the cancellation of removal application. The statute only allows 4,000 of those to be granted every year for the entire United States. So just the statistics that John gave you kind of give you an example that even a good case like this will still drag out a very long time. I actually just got a cancellation granted last week where the judge agreed to grant it back in 2015, and it took this long for my number of the 4,000 to come up. So these cases can wind their way through the immigration clock for years and years and years, and sometimes you might even end up having your child age out and make yourself ineligible because it took you that long.
Wow. All right. This is a little bit more specific over the detainment itself. So if a person is identified or questioned by ICE, Immigration and Customs, what kind of questions should they anticipate? What kind of questions should they answer or not answer?
Part of what we've been doing for many years, and I would say very acutely in the last few months, is reminding everybody, like I just did, of the importance of meeting with an attorney in a preventative fashion. Part of what statistics show is that about 15 to 20% of the undocumented populations do have some way to get legal status, but they may not be aware of it. So if you're working with people, please encourage them to do that. Second, part of what is happening or what's anticipated to be happening, and there's kind of a gray area as to whether it is happening in some places or in some circumstances, is an increase in enforcement activities by Homeland Security. What's called for again in the executive orders is a pretty dramatic increase in the hiring of additional agents, both on the border. There's a call for 5,000 additional agents on the border, and in the interior, where ICE has its jurisdiction, an additional 10,000 agents are contemplated in the executive order. Neither of those groups or initiatives have started because there's been no appropriation of dollars to do that. In anticipation of either more agents or more robust enforcement by existing agents, our advice to the community is to know your rights, know your constitutional rights, and these really start at home. Majority of arrests by immigration are happening in the home at this time. They usually are an agent who is looking for a particular individual. It may be somebody with a criminal conviction, or it may be somebody with criminal charges, or it may be somebody with a deportation order. We do think that those continue to be the priorities in terms of searching or investigating individuals. That's what the administration has said, and it feels like that continues to be the case by us who practice in this area. The kind of segue from that is, if I'm the person that immigration is looking for, and I'm at home, I'm the father, and 3 other members of my household are undocumented, it's really incumbent upon me, the person who is the target of that investigation, to know my rights and also to know the rights of the rest of my family members. So if law enforcement shows up without a warrant and seeks to talk to me, our encouragement is to insist that there be a judicial warrant. It is not common for ICE officers to get a judicial warrant, but rather to sort of intimidate their way into people's homes. Once they have entered somebody's home or been allowed to enter somebody's home, it is now common practice to ask every resident of that household if they have status. And so that's what we've begun to see. Instead of one person arrested, several people in that household or residence be arrested. So number 1, know your rights. Don't let somebody in without a judicial warrant. And number 2, if they have that warrant, you will have hopefully worked through how to turn yourself in and not consent to a whole search of your house or the rest of your household to limit what we're calling those sort of wrong place, wrong time arrests. That's the beginning of a very long kind of know your rights presentation.
If confronted by ICE or law enforcement, should people show their red card?
Yeah, so the red card is a document, I think I brought them, that basically say, I'm invoking my right to not answer your questions without an attorney present. And that is our advice. Part of the challenge, obviously language is an issue, but also complex legal rights and responsibilities are here. As a person who is arrested by immigration, you do have a right to talk with an attorney. It may take a while for you to be able to be at a place where you can make that phone call, but it is our advice to not answer questions without an attorney present. And the red card is a way to communicate that if you get nervous or if you're uncertain, even who the person is that's asking you.
And I've had situations where an individual did exercise their rights to not allow the ICE officer inside the house, and then later contacted me, and then I arranged a meeting with the individual and with the ICE officer, either at my office or at immigration, so that we can discuss all of that. And that's usually in a situation where I know that there's something that I'll be able to do for the individual, just like John said, that there might be something that they didn't even know about. And so, yes, definitely they should be contacting an attorney, and we can even arrange those types of meetings with the local ICE officer.
And specifically, if detained, what kind of process is it
another great question. It's a bit of a mystery for people who don't interact with this system. Here in Minnesota, we do not have an ICE holding facility. So people who are being detained on ICE's authority are held in 4 county jails. The kind of chain of events usually is, once you have been put into ICE's custody, you will be detained in one of the local county jails, and assuming that you don't have a previous deportation order, because that's another scenario we can talk about, but assuming you're just one of the individuals who's been here without status, you don't have a previous deportation order, you do have a right to both an attorney and to see an independent immigration judge. Our goal through our office and other nonprofits is to provide access at your first detained hearing to counsel. There is no public defender system in the deportation courts. So the way the law reads is you have a right to counsel, you have a right to an attorney, period, at no cost to the federal government, which means nonprofit or pro bono or private attorneys are filling that role or trying to fill that role. At your first hearing, one of the very first things that will be determined is, do you have a right to a bond, to pay a bond, to get out of detention? And that's part of what our project works on, is to make sure if you have a right to a bond, the judge is aware of that, and that the judge sets a reasonable bond. It also is possible that when you're detained, the ICE agent himself or herself sets a bond for you. We're beginning to see a change in that practice here locally of ICE agents refusing to set a bond, and that's a very fluid new development. Even though people are eligible, they're not setting it, basically saying you've got to ask the court for a bond. We're not sure where that's going to end up, but that is a new approach. It forces people to be detained for a longer period of time. If you're able to bond out, if you have an attorney, statistics show that you're about 4 to 5 times more likely to prevail if you have an attorney and if you've been bonded out. One of our sort of second most common suggestions for people who either are themselves at risk or know someone who's at risk is to begin saving money for that bond. In the world of immigration, almost everyone is required to pay a cash bond, and the average cash bond is between $7,500 and $10,000. So that's your reaction that I can hear up here is the same reaction that the immigrant community has. Our advice is it makes a world of difference if you can pay that bond, and people know that if you're at risk that they could be coming. Our advice is to begin to work together with your family, with your extended family, with your faith communities, to think about how would you come up with bond in an emergency so that you're not kind of caught unprepared for that. Because the difference is so dramatic to be able to pay that bond versus not pay the bond. The last thing I'll say, and we're really just touching the beginning of the process, if you are unable to pay a bond, and you're low income particularly, the demand for representation is so great that there's only a few agencies like ours that can take those cases, so that's a problem. The second is for private attorneys to drop everything and to pick up a detained case really means that you have to let go of a certain amount of your already full caseload. So bond is the most important piece of kind of preparing for a new heightened enforcement atmosphere.
Just a couple of follow-ups on that too, for things that are going on the ground in the Twin Cities. If that ICE officer says you can pay a bond, if they set a bond and allow you to go to the judge to reduce it, both because we're still short-handed with judges, meaning that you have probably 10 to 14 days before you can even see that judge to reduce the bond, and because of the tendencies of the judges in Minnesota to not really reduce them much, our advice always is if that ICE officer allows you to pay bond before your first court hearing, and you can do it. Don't wait for the judge to the hearing to try to get a lower bond. Just pay the bond because you'll have so many advantages once you're able to be out of custody.
If they don't have the bond, can we revisit the questions? Where, again, county jail
Okay.
or
So, and again, as John said, the four jails, are there still people in Ramsey County? Okay, so it's Ramsey County, Sherburne County, which is Elk River, Freeborn County, which is Albert Lee, and then Chaska are the four places where immigrant detainees are being held. The agency wants to have detained cases wrapped up in 90 days. So your case will be begun and over with within 90 days. And as far as if loved ones can visit, yes, but it's not face-to-face, so like you would go to Sherburne County and go to their video facility and be contacted through a video screen to the inside of the jail. So there's no face-to-face, there's no being able to hug or anything like that. That's one of the saddest things that I've seen is once somebody is picked up and in custody, if there's no further chance to get that person out of custody, they won't even be able to get to hug their children goodbye before they get to court. It's breaking glass walls. You're not going to touch them again.
that's a good segue into a little bit back to children. So the placement of minors. If a parent or guardian is detained, what is ICE's procedure for placing the student with a guardian or other adult? Or how is the school notified of this change?
So I'm not really sure about what ICE's procedure is. My understanding is that if two parents are undocumented and there are U.S. citizen children, then I think ICE tends to leave at least one parent with the children. They don't round up the entire family, but maybe the gentleman to my right can explain a little better.
Part of what I've been saying in almost every public presentation on immigration since the inauguration is that there's really a proviso that should be issued by all of us. One is, and it basically goes something like this, that what we're sharing with you today is what we know to the best of our ability in a quickly changing, volatile, and fluid situation. And check back, could be different tomorrow, or could be, some of these issues could be different depending on changes at the highest level. So yeah, for the most part, what we've seen in terms of the culture of ICE, I would say over the last two administrations, has been an awareness that in most non-criminal arrests, where there are minor children in the home and no one to take care of them, ICE will leave one of the parents, or even if it's a single parent, allow that person to proceed through removal, but beyond order of supervision, be outside of detention. I'm not aware of a dramatic change in that culture yet, but it also would not surprise me if it has changed or if it's in the process of changing.
And that also even applies to cases where the individual would be considered mandatory custody by the statute. They will still allow a single parent, for example, to not be in custody in a situation like that. So, and again, things can change, but the ICE agency is not entirely without a little bit of grace.
One thing I would like to add, though, for children who are born here in Minnesota to unmarried parents, fathers, even if they are on the birth certificate of their children, do not have any custody rights to those children unless they petition for it with the court. So that's something that surprises a lot of people. Minnesota law says that single mothers, even if they're in a committed relationship, and if they are unmarried legally, have sole physical and legal custody of their children. So one thing that parents might want to do to help prepare for some, if they are concerned about deportation, is to either get married to their long-term partner and mother of their children, or go to court and get joint custody of the children. Because if we have a situation in which mom is picked up, dad's at home with the kids, dad will then have to kind of scramble to go to court to get custody of the children. Realistically speaking, no one is going to come and take the children away from a father who's on birth certificates and is taking care of his children. The county foster care system is not interested in doing that. But schools may need the order in order to allow the father to make decisions about school. Hospitals may need a court order as well. So it's something that to kind of prepare is a good thing for people to get taken care of now.
That was one last, going into the next one. How does the school get clearance to communicate with the person the student was placed with, or what is the documentation required? So lots of communication.
Right, so if it's a parent, again, usually schools, as long as there's a court order granting joint legal custody or granting custody to a parent, the schools typically have no issues communicating that. I think most schools too, as long as there's some sort of documentation from a parent saying, granting authorization for the school to speak to this person about the child or pick up the child, the schools typically don't have any issues with that.
One thing I was going to say, you've heard me say it a little bit, just want to be clear around another scenario. So one of the priorities, both under President Obama and under the current administration, includes people for enforcement, priorities for enforcement, includes people who already have a deportation order, but have not left or have not been deported. So a lot of what we've been talking about for bond, seeing a judge, kind of time to deal with family issues or property issues, does not apply if you already have a deportation order and you're picked up. What happens in those circumstances is ICE executes that order. They basically use the pre-existing order, and that is the basis for your removal from the country as quickly as they can get those logistics together. You do not have a right to bond. You do not have a right generally to see a judge, and you will most likely not get out, regardless of the fact you have 1 or 10 U.S.-born children. So it is a very dramatic, different set of events that face you if you have a prior deportation order. The same thing is true if you have something called an aggravated felony, or you're mandatorily detained under the statute, under the immigration statute. You are not eligible for a bond. You can see a judge, but you likely won't get out unless you win your case. So, right, I wanted to be sure that if you left and you sort of have this sense of optimism that anybody picked up is going to be able to pay a bond and get out, that is not the case for a fairly significant number of current arrests and priorities.
One last question regarding children. What are the odds of reunification of deported or detained immigrant parents and their kids who are in foster care? What does that process look like for parents within the legal system?
So most children of undocumented parents do not end up in the foster care system. Foster care is generally the result of what we call a CHIPS case, a Children in Need of Protection and Services case. That is for children who are abused, abandoned, or neglected, or there's significant drug use, that sort of situation. So the standard, not standard, but the more typical thing that happens to children of deported parents is that they are left with family members. And that's where the delegation of parental authority or the standby custodian forms come into play. Because with the delegation of parental authority, that person taking care of the children can travel internationally with the children, can bring the child back to whatever home country is, as long as they have a passport and that permission from the parents. As for foster care, like all of the court system in Minnesota, is based on the best interests of the children. So it's not unheard of. My office actually has a CHIPS case in which the child is actually going to be sent to her father in Mexico. That was what the court determined was in her best interests. But it's a long process. It's not easy. There's a lot of agencies that are involved. So to say what are the odds, it's purely case specific.
And as far as reunification in the United States, a U.S. citizen child can petition for their parents once they turn 21. And then they have to take a look at that parent's individual case to see if they have any bars from the United States, from returning to the United States. The most common would be a 10-year bar because of either being undocumented in the United States for over a year, or because of a deportation or whatnot, where they may have to wait outside the United States for 10 years. So reunification in the United States is possible, but it usually will take years before that's going to happen.
We'll switch. 360 Communities works with domestic and sexual violence prevention. There are reports of an undocumented victim of domestic violence being detained by ICE at a courthouse just after she got an order for protection. Her abuser may have retaliated and tipped off the authorities that she was undocumented. Is this happening in Minnesota, and should we be concerned about the threat of this happening here?
It's a good question. Obviously, somebody's following the news. Part of what's going on, this is my perspective, I'd be curious what my colleagues' perspective is as well, is part of what's happening in this moment of very high fear and very acute attention to deportation, to the executive orders, is when a scenario reaches a level of media attention or national attention. A lot of us are kind of freaking out, and it gets shared through social media. And there's this level, both by practitioners and social workers, of, I think because we're all on heightened alert, of thinking, oh, does this signal, some new wave or some new initiative, some change in current practice? To answer the question, so I think that's happening, and I think I always have to try to, when I read one of those stories on a national level, sort of say, are there more facts? Is there additional history that's not being covered by, a pretty superficial media story? What's the rest of the story? And in a number of some of these high-profile cases, both this one as well as for some of the Dreamers that have been arrested, my assessment is that we have not seen a dramatic or even incremental change by ICE, by Homeland Security, in going after victims of crime. We have seen this incident that happened. There was one report of somebody being picked up here in Minnesota, but there tends to be, from my perspective, as of at least today, other reasons for ICE's interest in some of the people who have been covered in these stories. Our office does anywhere from 20 to 25% of our cases every year are for victims of crime, primarily U visas, some trafficking cases, some work for abandoned juveniles, but mostly U visas, and these are crime victims, undocumented crime victims who've cooperated with law enforcement here to stop that victimization. We continue to file those cases. We continue to have people come forward, trust us, and we still encourage people to contact and trust local law enforcement. We have not seen a dramatic or even incremental change in the treatment of victims or OFP requesters under this administration. And I think that's important for this community to hear. We also are paying very close attention because we are in a unique role of advising some of these very clients or potential clients who are contemplating trying to get out of a violent situation, or is it safe to contact local law enforcement? It is definitely in the news on a daily basis. If you follow the bill that was just signed in Texas, there's a big outcry from, I think, all of the major city chiefs of police in Texas saying by requiring law enforcement to be involved in immigration enforcement, you will prevent people, you will scare people from contacting law enforcement if they're scared and if they're being victimized, because that simple call to your local police office could result in you being turned over to immigration. So it's, again, one of these issues that keeps percolating, and stay tuned. That's what I would say.
Have you heard of any federal funding agencies are requesting immigration information and legal status of the clients that we're serving with that federal funding?
No. I just kind of wanted to add to what John was saying. A lot of my clients are undocumented and they come to me for something pretty simple like a divorce or a custody issue. And there's a lot of fear from people of just using the resources that are available to everyone in Minnesota. So people who are scared to go to family court and get a divorce. And I think it's very important that we remember that immigration, Department of Homeland Security, ICE is separate from the family court system, from the domestic violence judicial system. So I can't control who might happen to be in the courtroom on any given day, but a family court judge is not the same as an immigration judge. They do not have the power to make any sort of immigration decision. And as far as I am aware and what I have seen, they are not reporting anything to ICE or to DHS. So we get a lot of people who are scared even to apply for public benefits. People who have children here, even if the parents are undocumented, the children are citizens, they qualify for public benefits. The children do. They should apply for those things. They're not sharing that information. Even parents are afraid to ask for free and reduced lunch for their children, scared that the school will report them. Overwhelmingly, the schools are not, that I've spoken to at least, are not reporting those things to ICE. So I think there is a lot of fear out there, and people need to remember that there isn't some large database that ICE has access to of everyone's name, and they can just click through and see if someone has status.
One thing as I read this question again and try to imagine where it came from for whoever created it, if you're listening to us and you're not familiar with this, I don't want you to feel like we're saying people are irrationally scared. We do believe that part of a natural outcome of very, very dramatic changes in enforcement culture that this president has announced and that are in the executive memos is to retract, is to go back into as much hiding or safety as possible, and that's a natural reaction. But it is what's in those executive orders, what was said on the campaign trail in many instances that have both begun that fear and then crystallized that fear in the executive orders. So there's a provision that I wonder if might have been behind this. Number one, there's the call to withhold federal funding from any quote-unquote sanctuary city. That's been in the news a lot. That currently is on hold because of litigation on the West Coast. So that portion of that executive order is on hold. No city has been withheld or has had any money withheld under that. But again, it's in the news every day. If you happen to be undocumented and hear that, you may not be able to distinguish what's real or what's coming. We as attorneys can't figure that out some days, to be honest. The second thing is that there's a provision in one of the executive orders that says, and this again is a dramatic change, that privacy protections for any non-citizen who is not a permanent resident or naturalized citizen no longer apply. So previous privacy standards and protections for publicly held data for refugees, for asylees, for parents of undocumented kids who get WIC. There's a whole group of people who are here, many of them with legal status but have not yet reached that permanent resident status, where suddenly they start hearing that privacy may not, their data may not be private. What people hear when that's raised in an enforcement context is ICE could suddenly look at my public school information. I've had a bunch of questions from public schools or even colleges about data. Hospitals can ICE seek data on treatment of people with emergency medical assistance, the majority of who are undocumented. And then they're sort of to finish underscoring why people have a reasonable basis in being frightened in this changing culture we're living. There was a draft executive order that has not yet been issued that basically says if you're poor, if you've used public benefits, even if you've reached the level of a permanent resident status, your status could be taken away because you're not being a productive member of society. So all of this is new, it's all out there, it gets consumed in a way it's much easier to consume with social media and 24-hour news.
Immigration is going into courts. We hear this, as John was talking about, we hear that a lot more out in California. It's interesting that the ICE officers, or the hierarchy in ICE said, well, the reason that we're going into the state courts to find people is because they've already been through a security checkpoint, so we know that they won't have weapons, and so it'll be easy for them to get picked up there without having any fears for the safety of the ICE officer. I'm not seeing that in Minnesota. I don't know if either of you have heard of any ICE officers going inside state courts in Minnesota.
I was at a panel on Friday with a group of prosecutors, and a prosecutor from a local county in the metro said that 4 different defendants, I want to say recently, within the last month, I think was his frame of reference, had been arrested in the stream of hearings leading to either their plea or sentencing. So it was all pre-conviction, plea that people had been arrested. So we are seeing that. It's not as widely or as dramatically seen, I think, as what was making the news in California, but that also is a change. We've also heard of at least one incident where somebody was reporting to a probation officer and ICE was there to arrest that person. So once again, we're put in this challenging situation where we need people to trust the state court system, to trust local law enforcement for their own good, but also for the good of the rest of the community. If ICE begins to make arrests anywhere along that chain of interacting with local courts and local law enforcement, the natural reaction will be to withdraw from those processes. So instead of going in to pay your ticket for no driver's license or no insurance, people will be absent if that fear turns into more of a predictable reality, and then you have a warrant out for your arrest, and things get worse.
Just a quick note, I do think it is important to understand that orders for protection, harassment, restraining orders are civil orders. So you do not have to have a police report in order to request an order for protection. It is based completely on the petitioner's affidavit, and it goes in front of a court. They are also confidential, so there's a distinction between what is available publicly. Criminal records, you can put in anyone's name into the Minnesota court database and look up their criminal history. Orders for protection, harassment, restraining orders are confidential in that system. So there is a distinction. I have not seen anyone for orders for protection. I have not seen any ICE involvement just through the order for protection case. But yes, violating the order for protection is a criminal case that can have severe immigration consequences.
One last question, then we'll open it up to questions from the audience. Please explain briefly U visas, T visas, and VAWA, or 360 self-petition. Also, have any of you had any experience in helping victims with any of these things?
Yeah, so this is what I was talking about a little while ago. The U visa is a victim for somebody in the United States who has been a victim of a serious crime here. The crime happened here. The person who committed the crime was here when it happened. We make that distinction because some people ask us about something that might have happened before they immigrated, and that does not qualify. There's a list of about 30 qualifying crimes for the U visa. In order for this to work, you have to have been a victim of a serious crime, domestic violence, sexual assault, assault of a minor. If your minor child is assaulted, the parent is able to protect that child. So those are the most common scenarios that we see at our office. We do, as I mentioned, work with a lot of crime victims, and we work very closely with local law enforcement to understand this federal remedy. There's a training and a handbook put out by Homeland Security directly targeted at local law enforcement if they're not familiar with this. There are officers from Homeland Security here in Minnesota who do some co-training at times with us or on their own with local law enforcement to understand the U visa. For it to work for an individual, it must be signed by local law enforcement. So a certification that the victim herself was helpful in the investigation or arrest or a conviction. You don't need a conviction, you just need to certify that they were helpful in any one of those three areas. And then once that local law enforcement signature is obtained, we can send it to immigration, where immigration then makes a decision if this person merits the discretion to get a new visa. As Mark mentioned earlier about cancellation, this is another area of the law that suffers from far too many available visas and far too high of demand to give out these visas. So currently people are waiting 3, 4, 5 years with a projection of maybe as high as 8 years. The maximum number of new visas granted per year is 10,000 under an arbitrary statutory cap when this was created. The powerful thing, and a lot of people don't know this, it's worth taking an extra minute for those of you that work in this area or come in contact with people who might be victims. If you're an undocumented mother or father and your minor child, even if that minor child is a U.S. citizen, has been a victim of sexual assault, of some kind of a serious crime, the law is set up to encourage you as the protector, as the parent of that child, to seek protection, to contact law enforcement, and by doing that, you yourself as the parent can qualify for a visa. So that's the U visa. The T visa is for victims of trafficking, and these are victims of either sex trafficking or labor trafficking. There are fewer of these cases, both in Minnesota and nationally, but the way I talk about them is you generally know them when you see them. Women, a common scenario is women who are brought from abroad to be prostituted. There was a case maybe 5 or 6 years ago on Lake Street of women from multiple countries whose passports were all withheld and who were moved around the country on a very regular schedule and terrorized. Often their family members are threatened back home if they do not cooperate. For labor trafficking, another Minnesota example of cases that we're working on include people brought in for farm work who are not paid and treated well, paid an accurate wage, and who are basically in a slavery type situation. So that's the U of the labor certifications. The U and the T visas. For VAWA, this is for the Violence Against Women Act in the immigration context. And the way VAWA works is if, as you know, if you marry a U.S. citizen, that U.S. citizen spouse can apply for immigration benefits for their spouse. If that spouse is abusive, this law allows the victim to leave that abusive marriage and finish the petitioning process on their own. Again, the public safety benefit, the public safety goal in all of these is for victims to seek law enforcement protection, local law enforcement, and later immigration protection to stop that cycle of violence, get out of that violent relationship. So VAWA applies where the abuser is abusing a legal spouse, somebody who's legally their spouse, and U applies when there does not need to be that legal relationship. So that's it in a nutshell.
And just to follow up on the VOW, although it's Violence Against Women Act, it also applies to male victims too. And just to give a quick example, I had a very nice young man who was married to a U.S. citizen. They had a small child, but the U.S. citizen wife developed a very serious chemical dependency problem and just terrorized him, threatened to kill him, went after him with a knife. And all he wanted to do was just take care of his little boy. And we were able to get him and his boy out of there, and were able to successfully get him a green card through the VOW petition.
Sounds like a wonderful success story. Thank you for answering those questions. We're going to open up to any questions that you might have. If you'd like to come up to the mic, and we'll get you set. It's not that scary talking into the mic. I did it. Come on.
Here at Prince of Peace, we have a mission outpost serving a diverse community. And I heard this morning, and I don't know whether it's true or not, but I had heard that the numbers of people coming for services has gone down because they may be afraid that they're going to be apprehended and deported. What can we, as a faith community, do to try to reassure those clients?
What kind of services, sir?
Food shelf, dental clinic, clothing.
Basic health and safety services. It's a great question. We are seeing there's been reporting all across the U.S. of a downward cycle of people both requesting supportive services like that from nonprofits or faith communities, as well as undocumented parents pulling their citizen kids out of WIC or public benefits or even Medicaid, contacting their social workers and asking them to be removed from any kind of public benefits. To the best of our ability, the only thing that makes sense is that fear, as I mentioned, about the public benefits executive order, that draft order that went out. In terms of, from my perspective, the importance of having persons who work in food shelves, who speak the language of folks who are coming, who actually come from those communities to help reassure them what your overall motives are, to remind them in these days of heightened fear, that you don't have a connection to the government, that the information is confidential. Really creating a welcoming environment is, I think, the best thing I can come up with. If there are maybe leaders from the local immigrant communities that are using your shelves, reaching out to them and having them help spread that word has been also really effective. Probably not telling you anything you didn't already think of, but that's what comes to my mind.
I don't have anything more to add other than, come to places like this to gain the knowledge about what's really going on and what can be done.
Is it possible that a person does not know they have a pre-existing deportation order?
Yes.
So it's a little tough.
Right, and that goes back to one of the things John was saying is talk to an immigration attorney for sort of a preliminary understanding of what's going on, because we have things that we can do to find out whether or not there is a removal order. So, sit down with an attorney to find out what's going on, what are you facing. So, but yes, I'm actually working on one of those cases right now where the gentleman was ordered deported in 2013, and he just found out about 2 months ago, and so we're trying to.
Is it online somewhere?
If you know your alien number, maybe years ago you were given a work card for some reason, there is an 800 number that you can put the A number in order to find out if there's anything there. So it's not online, but there's an 800 number.
What I would say, just in addition to Mark's comment, part of the preventative consult with an immigration expert is, we ask probably 5 different ways about contact at the border. What happened when you tried to get here if you came without a visa? Were you overnight? Were your fingerprints taken? All of those questions that we ask as experts in the field really help us to determine, does this person perhaps have a deportation order? In an event where we cannot determine it, through our questions and the answers the person gives us, we can also do a Freedom of Information ask to try to get that information from wherever that contact happened. Because it is such a crucial piece of information, as I've mentioned, it is really a threshold that people need to know in these days. I'm glad to hear that people know what a red card is or know to talk about red cards. Red cards are nothing more than a know your rights card. I think if you just type in know your rights immigrants into Google, you'll get 7,000 opportunities to download a portable card in English and Spanish or English and another language. I have some with me today, and I'll set them out, so please take them and share them. They are free. I think it's the Immigrant Legal Resource Center in California that creates them. You could order them for your food shelf or for your church and have them available. You can also download them and make them yourself. The ACLU has a good set. There's a number of organizations that make them.
My first question is for the moderator. I have 3 questions. Is that allowed? All right. I just wanted to ask a clarifying question. You said the provision in the executive order that might change the 14-day, 100 miles of the border to 2 years, entire country, could require additional rulemaking. Does that mean congressional action?
No, rulemaking would be the executive itself. So the President or Homeland Security says this is going to be our new standard, and they publish it in the Federal Register. The public has a chance then to send in our comments, observations, concerns, and then the administration ultimately will make a decision on what those rules look like. Usually, an administration gets its way when it tries to change the rules like this. If they violate the law, you can be sure in this climate there will be litigation challenging the underlying law.
Just a follow-up on that too, though, is one of the concerns I have about that is whether or not the administration would invoke. I believe there's a national security exemption to the rulemaking process, so they could promulgate that rule much more quickly than a normal rulemaking procedure. Because normal rulemaking for any agency can take years. There was a famous one that lawyers learned in law school about how to define peanut butter that took like 8 years to promulgate. We're hoping that it goes through rulemaking, but there's a possibility that they'll just say, because we decide that this is a national security issue, that we get to bypass the rulemaking and we'll just announce it. But again, then there will be ACLU lawyers, immigration lawyers going to the court right away to try to block that.
Thank you. My second question is, could you give us just some examples of things that cause mandatory detainment?
Mandatory detention is, there's 2 main areas. One is if you are arriving at a port of entry and you are seeking to enter the United States without a visa, then technically that's considered mandatory detention. Although we are seeing if that is the situation and you are going to apply for asylum, you may be able to be released on parole. If you are in the United States and you're picked up by immigration, mandatory custody is usually because of some combination of criminal activity. So if you have a conviction that would be an aggravated felony or some other combination of convictions, that would be considered mandatory custody also. 2 really quick things about that. Aggravated felony is a term of art. It doesn't mean that the crime was aggravated, and it doesn't mean that the crime was a felony. It was just something that Congress wanted to come up with to make it sound really scary. So we have misdemeanors that are aggravated felonies. So again, that's where you need to talk to an attorney to find out what your situation is. And also, as we talked about before, mandatory custody is only mandatory custody when they want it to be. So they have released people who are supposed to be in mandatory custody.
Okay, thank you. My final question, I work at a food shelf in northern Dakota County, and I'm our Spanish speaking on staff as well. And I think I would conservatively estimate about 75% of our undocumented population avoids getting food support benefits, because there's a pretty widespread belief that that can in fact hurt your immigration case. And I have just never had the opportunity to actually ask somebody who knows that that's true. So is that true?
If I understood your question right, you're talking about undocumented people?
People who are either in the process or planning to apply to change their immigration status.
Yeah, so part of what, and this is not new under this administration, there is a test for a public charge that has existed since 1996. And that's really where, some of this concern about public benefits, there's some that's fact and then there's some that's fiction. Basically, the existing law and rules say that if at the moment you're going to get a green card, it appears that you would be a public charge in the future, you could be denied your green card or you could be denied a visa to come to the United States. So that part is law, it's based on the law. Where it tends to get beyond the four corners of the law is what can be counted towards determining if you're a public charge. For those of you who are social workers, it means means-tested benefits. If you've received means-tested benefits, that can be the clearest example of likelihood of becoming a public charge and therefore being denied benefits. Use of a food shelf, I've never seen, and we only work with people who are low income. There is no occasion where I've ever seen use of or frequenting a food shelf to have been included.
They're not afraid of the food shelf, thankfully.
Oh.
Although I've seen it as some families have been checking with us to make sure that we're separate from the government, but no, they're afraid of food stamps when they're eligible. So, what does means tested benefits mean?
The other thing I would say is we also have to make sure people understand the difference between an adult getting it and their children getting it. So what we've begun to see is U.S.-born children who are eligible for food stamps or for medical services being withdrawn from those services, and that's not anything that has proven their inability to immigrate in the future. Means-tested benefits, the most common example is cash.
So
Minnesota Care does not count.
Okay. Counties pay you
Yep.
cash.
And here's where, again, folks who work in public benefits turn around and they say, well, John, I thought all undocumented persons or persons, most people who are applying are not eligible in the first place for means-tested benefits. And the answer to that question is yes, that's true. So the use of these other public supports, primarily for children, is not part of what will ultimately be calculated into your own eventual ability to get status.
Okay, so if a parent is receiving infant cash but on behalf of a U.S. child, that won't necessarily impact their
That should not.
Okay, great, thank you.
Yeah. Again, everything I say today is as of today. There is this draft public benefits memo out there that, when we read it, would, again, if it were to be enacted, change settled practice, and we need to be back here advising you all different on that. Also.
When people apply for the lawful permanent residency and need to get their medical exam, it's very expensive, and that is prohibitive for a lot of people. Do you know of any resources to help someone with that, like to go see the civil surgeon for their medical exam, or to go to public health to get their immunization documentation updated for their application?
Personally, no. I think that's one of the things that people just have to find a way to work up through it. I would recommend, just as you say though, if you can get your you can document your immunizations separately from the civil surgeon, then get that done in a more cost-effective way and bring that proof to the civil surgeon in order to do your exam. But it's just one of those requirements, that goes back decades upon decades of a requirement of permanent residency. So just like we were talking about for people who might fear immigration court and might need to save up money for a bond in the future, this is just one of those things that you have to do.
One of the things that we've developed, so there are only certain physicians who are on the list that can do these physicals. It definitely is worth calling around to see the different rates people charge. So that's the first thing that we usually encourage people to do. We've also seen, unfortunately, some refugees paying for things that they don't need to pay for. So if you got all of your immunizations as part of your refugee processing, you should not be required to do it. You just need to document that you have them. If you have those records, you shouldn't be paying for them. So those are a couple of suggestions. The last thing, it's been many years now, but there used to be assistance through Catholic Charities in the Twin Cities for some of these costs that poor people could not pay. I'm not sure if that still exists, but it's that same sort of place where you might get from church justice funds or things like that. I think there are more places that could provide support for paying some of these fees than realize that their community members are hung up by not being able to pay their citizenship fee or their exam fee. So if you're on any of those committees, start that conversation, or what are some of the costs that our community members might have that are prohibitive for moving forward on their cases. I think it's a great way also to show that you're in tune or listening to what the community may need.
Kind of a two-part question. So I work with veterans advocates.
Speak right into the microphone.
Okay, and something that has been coming up is kind of the consideration to return voluntarily to their country of origin. And what happens is some of these immigrant families don't even have a passport from their country of origin. And I know that their child would need their birth certificate and obviously a passport. But I think because of just lack of knowledge of our system, the idea that they could fly without a passport. But then just maybe if you could speak to that a little bit, but then also the idea that around like the consulate, so we have a Mexican consulate in Minnesota, and I know some of them travel to Minnesota, but looking on their website and getting that information is really not easy to find. So if you have a resource that could make it easier to know when traveling consulates are coming to Minnesota.
Great questions. Again, when we're in the community, really in the last few months, one of the other suggestions we're giving is get your passports in order. One of the things that is very hard to deal with sometimes for U.S.-born children, if a parent has already been deported, it is required that both parents sign an application for a U.S. passport for their children, so that can be a delay. If they're detained, it can be a delay or an impossibility. So getting U.S. passports now, again, preventatively, is the easiest time to do it for U.S. passports. In Minnesota, we now have the Mexican consulate and the Ecuadorian consulate with regular business hours. Their work has increased dramatically in terms of providing basic documentation, passports, and consular cards to their citizens. Even though they're based in the Twin Cities, they also travel to Greater Minnesota, as you mentioned, so they call it their mobile consul. I don't know about the schedule or the ease with which you can find those two Minnesota consulates schedule. If you're having trouble, I do encourage you to reach out to them. They co-present with me a lot and do take constructive feedback very seriously. For the other countries' consuls that come, Guatemala comes regularly, El Salvador comes regularly, Colombia was here just maybe a week or two ago. Our office tends to get notice of that, and we put it on our office Facebook page. So here's a shameless plug. If you are interested in either following what we're doing, looking at some of the public policy we have, or just looking at our announcements for the community, please like us on Facebook at Immigrant Law Center of Minnesota. And the last thing I'll say is we also have a regular communications email and other communications. I brought a clipboard. If you'd like to receive those, you can sign up, or you can do it online as well.
Do want to add a quick note about obtaining a U.S. passport. So yes, typically if both parents are on the child's birth certificate and you're applying for a passport for a minor, both parents do need to sign. It happens on occasion that parents break up and one parent does not know where the other one is. You can go to court to get a court order to allow the parent who is living with the child and wants to get the passport without that parent's signature. You can also try to do it through the passport office by just explaining on the application how you have tried to get access to the other parent or tried to get their signature. Most of my clients have very limited luck with that. They still say, no, we need a court order. But you definitely can do that. It's a custody case, basically. So even the typical situation is a mother who is a single mother. She already has custody of her children, but she wants to go to court in order to get the passport. And so that happens fairly frequently, and it is another option. So just because you don't know where the other parent is does not mean you cannot get a passport for your child.
I work for the school district, and I have a student who, she just turned 18. She's undocumented. She doesn't qualify for DACA. And she's being asked to testify against her father in a CHIPS case that's been taken further into criminal court. Should she talk to an attorney? If she should, what type of attorney? I mean, there's questions about the S visa as well.
Yeah, great. I'm glad that you're asking the question on her behalf. You said she is 18 or turning 18? Yeah, I'm sure she would be grateful to have anyone like yourself help find a resource, whether it be our office or a private immigration attorney. I don't know the nature of the underlying proceedings, but it's definitely something worth looking at. Could it meet the standard for a U visa? An S visa, it stands for snitch. So when I hear that, that usually means the person is helpful for the prosecution of whoever they're asked to testify against, but it's really in her best interest. She has nothing to lose in trying to get an appointment with a qualified immigration attorney, and a lot to gain as well.
I work specifically with clients who are on probation, and I have a client who is facing some immigration issues. What sort of hope or options are there for clients who have criminal background histories, and what can ideas that?
Yeah, so our office, in addition to the legal work and policy work we do, we also we provide technical assistance to the state public defender system on this very question of the intersection of criminal activity, criminal charges, criminal convictions, and deportability. And part of our work, and this is required under a U.S. Constitution, the U.S. Supreme Court constitutional case called Padilla. Padilla was a case for a permanent resident. He was a Vietnam vet. He had a minor drug charge, and his public defender said, "Oh, you've been here 30 years, or 35, I think it was. You've got a green card. This is such a minor offense. Don't worry, you won't be deported. Just plead, and you won't even do any jail time." And he was right on everything except the "you won't be deported" part. That case ended up going all the way to Supreme Court. The Supreme Court said that a criminal defense attorney, public defender, or private criminal defense attorney has a professional obligation to give accurate advice about the deportability of charges or convictions. So you can't just sort of throw it out and say, well, you might be deported or you won't be deported. You have to know yes or no. As you've probably, if you've learned nothing else today, this is an extremely complex area of law. The state public defender system does not know immigration law, so they call us to help walk through these two parallel systems. So that, because it's complex, our job really is to try to study each and every one of these charges and each and every person's case to try to find outcomes that do not lead to deportation. And so, that's what I would say. If you have individuals who are, in the probation context, they've probably already, been sentenced, but they still may have doubts or questions about their deportation consequence. Certainly worth referring them to any of the private attorneys or our office to try to clarify that. There are also, because this Padilla decision happened in 2009 or 2010, there are people who were advised to plead guilty prior to that may be able to go back in and undo those guilty petitions based on bad advice or incorrect advice from their criminal defense attorney. So that's another option.
Any other questions right this minute? Okay, I'll jump in with a few more. Sounds like a lot of people here work in helping with services. Are there any services that will help families pay for birth certificates or passports for their children?
I'm not aware of any that will help pay for a passport or birth certificate. I think the passport fee is now $160. So around there, birth certificates, to get copies of them, are about $26 through the state court system, through the state system.
How about, are there any services that will help a family with the cost of travel to return to their original country?
Again, no, I don't think so. That's not that I'm aware of, unless you're going to get into an individual situation where they are maybe a member of a church. It's a piece where they might get help from one of their church communities or neighboring communities. But there's no, to my knowledge, there's no direct way of seeking help.
The only thing I would say is if you're not familiar with, or if the people that you're working with are not familiar with the consulates do have a number of resources. That would be my first suggestion, is to contact your local consulate. For a while, we were working on DACA cases for the Dreamers. They did have dollars to help pay for the application fee for some of the initial DACA applications. So that's probably the closest source for people who truly are indigent and unable to meet some of these costs.
Are the Trump administration's extreme vetting measures fair and lawful?
I thought we weren't getting into politics.
Unfortunately, it's not politics. We have to talk about what they're proposing, and even though the reality is that this is coming from one administration, what we've been forced to do is to spend a lot of time talking about the intentions of Donald Trump, both as a candidate since he's taken office, as you've seen in the litigation, even in yesterday's arguments at the Fourth Circuit, the very intentions, the promises made as a candidate are at the root of whether or not his institution, his executive orders are constitutional. So it's not us who's sort of inserting them. We are analyzing what's been put in front of us. I think it's a bit of a trick question, because there is yet, at least as far as the last time I heard about extreme vetting, I don't think there's been a set of questions created yet. They are called for in the executive orders, but we have not seen a series of questions to sort of fit into that category of extreme vetting that he promised as a candidate. It is coming. It is called for in the executive order. When they come out, you can bet that we'll be analyzing them as any lawyer would be, to try to properly advise our client.
This is probably a simple question to a complex answer, but what is the current roadmap for full citizenship in the U.S. for immigrants?
Well, just to talk about some of the types of people that we've been talking about here already, let's take the undocumented mother or father of U.S. citizen children. They would have the ability to, if they were picked up by immigration and brought in front of an immigration judge, they'd be able to apply for the cancellation of removal that we talked about. That process takes years and does result in a green card. And then once, for example, the one that I just got granted last week, so she now has a green card as of last week. She's a mother of 3 children, has been in the United States since, was it 1999? And she received her green card last week, and so then she would be eligible for citizenship in 5 years, because you have to have a green card for 5 years before you can apply for citizenship. If she remains a person of good moral character for those 5 years, then she applies for citizenship. Right now we're seeing that process take about maybe 6 to 9 months before they'd be able to take the oath of citizenship. So, long.
I think part of what I hear in that question too is, for years, many of us have been working on public policy issues. The way in which that's been talked about is, how do we create a pathway to citizenship for people who are undocumented? So I'm not sure if that's what was behind that question. If it was, what we're talking about, what the current reality is that there is very little conversation around legislation that would create a pathway for the 11.5 million people who are undocumented. I mean, it's all enforcement all the time at this point. There is one kind of glimmer of positiveness out there. President Trump was challenged from a couple of Republican senators before he took office about whether or not he was going to cancel the DACA program and start deporting Dreamers as well. So Senator Lindsey Graham kind of took the lead and said, if it turns out that he does cancel the DACA executive order of President Obama, I will introduce legislation in the Senate to give them a more permanent status. So that bill has been drafted. It has not had any hearings yet, but it's sort of served as a notice.
If you are a U.S. resident and you want to bring your parents or children here to the U.S., how do you petition for permanent residence for them?
So permanent residents can petition for spouses or unmarried children, whether they're under 21 or adult children. Only a U.S. citizen can petition for a parent or a married adult child. Essentially, you start with a visa petition where you need to establish that you are a U.S. citizen or lawful permanent resident, and then you need to establish the relationship. So if it's a parent, just demonstrate that that's your parent. If it's a spouse, you demonstrate that you're legally married and that it's a bona fide relationship, that you didn't get married just for a green card. And then, depending on what the relationship is, you have to wait any number of years before that the beneficiary would be able to apply for a visa at the consulate abroad, or if they're in the United States, apply to change their status to permanent resident. And those wait times can be decades long, depending on what the country of origin is from and what the relationship is.
Any other questions that you've thought of in the interim? Come on up.
I'm a social worker and I work with adults that have mental illness. And I'm working with a client right now who's actually on the deportation list to Thailand, but the borders are closed. They're accepting people back. So I'm just wondering what somebody like that, what you can do for them.
are circumstances where sometimes we have to let people go in order to bring them back, depending on their circumstances with family or other circumstances that we might be able to get this person status some other way. There's also a couple of unique circumstances like a U visa where you can get lawful status despite a deportation order. So it would have to depend on the facts of the specific situation. Again, it's that preventative consultation meeting with an attorney to find out what options are there, what can be done. Sometimes there simply isn't anything we can do, but you have to take a look.
One thing I would say, if you've seen the news, the 8 young men from Cambodia that were in the news a fair amount here from Minnesota. What ended up happening with that circumstance is people who come from countries where their home countries will not accept them because there's not a formal repatriation agreement will be ordered deported by the U.S. government. And then the deportation can't happen. So people are kind of in limbo. Usually they're eligible for a work authorization card while they're in limbo. It's usually an annual card, you can renew it. So if that's, if he doesn't have that, a lot of poor people, particularly poor people with mental illness, they might have told that but have no knowledge or are unable to figure that out on their own. We do work with a fair number of our clients who do suffer from trauma and mental illness. So it's definitely worth the preventative checkup. The other thing that we saw play out with the Cambodians is, when deportations resume to a country, it's almost too late for that person to get help from an attorney. The Cambodians, I think all of them in Minnesota, were put into custody and did not get released from custody. As you heard me say earlier, they didn't have a right to get out of custody because they already were ordered deported. And so many of them, I think now, the ones that have not yet been deported, have been in jails, not just in Minnesota, but shipped across the U.S. For at least 6 months. It's been, I think, 6 or 7 months. So heartbreaking for those families. The positive side of what we know as attorneys, I don't want to get people's hopes up, but at least 2 and maybe 3 of the Cambodians did get emergency legal assistance, and 2 of their cases were reopened. One was released from custody back to his family. So miracles can happen sometimes, but the likelihood of them happening when you're detained is much, much less. So getting somebody on board and to re-examine. What we found for people with mental illness is, particularly the Hmong community who've been here and have not been deportable, ever since the late 70s. We are probably talking about hundreds of people with deportation orders. We know that President Obama started to apply pressure in his last trip to Southeast Asia to repatriate folks. It became part of the campaign for both candidates. Both candidates vowed to get tougher on returning criminal aliens. And you could bet that President Trump will continue that pressure that Obama started to eventually get repatriation agreements signed with Laos. So the impact of that in Minnesota on communities such as the Hmong community, where it has become common belief that they will never be deported, that the U.S. government can't deport them because they were our allies in the war in Southeast Asia. And that is not the case. Now is the time to try to get some assistance while there's still hope.
Yeah, and we're starting to see that in the Somali population as well. There's been stories about people going into their every 3 months check-in with immigration and then they don't come out. We know that there have been 2 planes full of Somalis sent back to Somalia so far this year, and I believe there's another one going at the end of this month. And so again, these are people who have been in the United States for a decade or more and who thought they would never get deported.
not do?
Yeah, so the question was our observations or interactions with local police around deportation, right? You know, we haven't mentioned this yet, but going back to the executive orders, the two executive orders issued on January 25th, one was directed at the border and one was directed at the interior. In both of those executive orders, the president has now called on Homeland Security to develop something called 287G agreements with local law enforcement. And what that means, it refers to a section of the Immigration Code. What it means is that local law enforcement can seek to be trained to enforce immigration law. And that's true, you know, it's called for under both the interior memo and the border memo. It's never occurred on the border before, so that's again another example of these dramatic changes. It is not mandatory, so that's one of the first things we say. Local law enforcement does not have to do this. It is not set out in the executive order as mandatory, and it is not set out in the statute as mandatory. The question we usually get after that is, can the federal government force local law enforcement to do it? We have not seen an indication of this administration that it is intending to force local law enforcement or local jurisdictions to do this. We also don't know, no one knows what exactly they mean when they're talking about withholding money from sanctuary cities. So you begin to see these issues again getting connected in the absence of clarity in the executive orders. Some jurisdictions believe that an aggressive federal government could say, unless you're participating in a 287G program, any federal dollars you use for law enforcement could be withheld. That would be a very aggressive approach outside, from my perspective, outside of what's contemplated in the statute. So all of that's theoretical. In terms of actual on-the-ground interaction, I have not seen a change in local law enforcement attitudes, you know, since the election, since the inauguration. If anything, if you've been reading the papers, and we do work with Minneapolis-St. Paul police chiefs, those two departments particularly have gone out of their way to make sure that the immigrant community knows they are not working with immigration for the very reasons we've been talking about. They've issued videos in multiple languages with officers from the Spanish-speaking community, for example, saying, please continue to trust us. Please, if you've been a victim, come forward. They've been at a number of events with us. I see we have a local law enforcement person here who can answer that question for whatever jurisdiction he's from. But what we found, and I've been doing this for a long time, almost 20 years, is most local law enforcement really care about doing their local law enforcement job. And they have enough to do. That's generally what they'll say in public, and I believe them, with keeping everyone in their community safe. And it's a community policing model, and it works with the laws that exist to protect immigrant victims as well, so those two work well. And generally that has been my experience in Minnesota. Some are more inclined to be public about that work in support of the immigrant communities, usually when there's more immigrants in those communities. But that's my general appreciation.
General wrap-up question. What can we, as a community of providers, what can we do to help?
While I can still talk, I'll give a couple suggestions, because I get this question a lot. As soon as I finish answering, I'll put my clipboard over to the back of the room. Please sign up for communications. This is, as I mentioned, a very quickly changing area of law. A lot of public officials, local as well as federal, truly don't understand the complexity of the issues that you've all been exposed to here today, so I give you a lot of credit for sitting through 2 hours of lawyers talking. Hopefully it was helpful. Don't be intimidated by it. Use the information you heard today to begin to develop your own confidence. You probably know more about what's going on in immigration than most of the people in your circles because you were here today, and share that information. You know, if there's a question you have, look to a reasonable source, including the Homeland Security website. There's a lot of good information on government websites. The second is, you know, these issues, all immigration policy and law issues, will be settled at the federal level. So pay attention to how your local officials are talking about immigrants, talking about refugees, talking about the president's executive orders and plans, and be active on those issues. And third, you know, in terms of the other thing I talk about is, especially when we're in a faith community like this, you have more power together. You know, find ways within your network to be welcoming. I've heard a number of really positive examples of ways to do that. What I've issued to my staff and almost everywhere we go is, you know, in an age where more and more people are intentionally made to feel unwelcome, how are we changing how we behave to intentionally create welcome? And that's not confrontational, that's a challenge to us, you know, as Minnesotans, as members of our communities, local communities, faith communities. But how do we make sure that anybody we come in contact in our different roles we have knows that they're welcome, knows that we're here to support them? And I think you can have, that's a very interesting conversation for you to tee up in any of the book clubs or social justice committees or faith communities or social work circles that you might have. If you don't know the answers, you know, contact us, we can give you some suggestions.
Wrap up, we're almost out of time.
I think John spoke pretty well for us on those issues. Yes.
Anika, do you want to finish up? Okay. Thank you so much, everyone, for coming, and please do, where you go, come find the clipboard. I think there's probably still some cookies, and, okay,